Dominic was talking almost as much as he did in class. Greetings, everybody. Several of my students and former students are here. Glad that I could get an audience. This is a fantastic time. What I'll be talking about is protected concerted activity in real time. We're talking about a period where so much is happening outside in the workplace. The previous speaker talked about the summer of strike, all of that stuff that was going on, including over 160,000 television and movie actors joined, 11,500 Hollywood writers who had already been on strike since May, protesting low wages, and eventually getting a contract, and thank goodness, because one of those writers was my daughter. The end of July saw last-minute contract negotiations which narrowly avoided 340,000 UPS strikers from going on strike, workers from going on strike. And in September, auto workers struck the big three American automakers and eventually got a deal. And then there is Starbucks. 150 Starbucks stores striking over things like banned Pride Month decorations, other terms and conditions of employment. And now on the eve of the National Day of Action, Starbucks and Starbucks workers united, and the union representing the baristas issued a joint statement announcing that they're ready to work together, agreed to bring discussions on foundation frameworks to achieve collective bargaining agreements for represented stores and partners, the resolution of litigation between the union and the company, including brand litigation and a fair process for workers to organize. Who'd have thunk it? And I found out about this while I was in Mickey Mouse Land. I was literally at Disneyland at a conference when all of the Darth Vaders were in the conference with me, as well as some union lawyers who said, guess what? Guess what? Starbucks is doing a deal. They're going to recognize the union. They're going to engage in collective bargaining and work towards a master agreement. And I'm saying, well, I know this is almost March, but it damn sure isn't April 1st. And they said, I'm not kidding you. It's going to happen. And sure enough, there were press releases indicating that was the case. So I am amazed and pleased and applaud the hard work and efforts that were done in this time where collective bargaining and worker voice is paramount. Now, talking about the paramount nature of worker voice, those of you who've taken labor law know that Section 7 of the National Labor Relations Act explicitly provides workers with the right to engage in union activity, and it also gives workers the right to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. Employer retaliation for Section 7 activity is unlawful. But other than the obvious, what does protected concerted activity actually mean? I've only spent how many sessions of class drumming that in? And we still don't know, do we? You better know. And so there's a robust body of case law that has formed around defining what protected concerted activity, or PCA, is, what it does and what it does not encompass. And there's an equally robust body of law tailoring it, narrowing it, and eliminating some aspects of it that was particularly permeated during that period that the Trump administration was in operation, and we had a Republican majority board. There's an ongoing tension between employees' interest in maintaining a safe and productive workplace and the workers' statutory rights under the National Labor Relations Act. These rights attach to all workers, not just unionized workers, and these rights are manifested in a variety of forms that reflect the issues of a modern society, such as COVID concerns, Me Too, race, social justice, immigrant rights. This board, in several cases, recently made endeavors to try to strike a balance between worker and employer interest, and with a varying degree of success. But the attempt is to clarify the employees' rights and the corresponding employer obligations at a time where worker voice is at a fever pitch. So there's a whole lot of cases that I could talk about to illustrate that are really cutting edge, particularly cases like Stericycle, which digs into how workers write their work, how employers write their work rules, making it clear that an employer has an obligation to make their work rules clear enough so that a worker could not look at that work rule and conclude that their Section 7 rights are being limited. There is McLaren-McComb, which is a return to a standard where if you get a severance agreement or you have to sign an agreement with respect to competition, that your severance agreement cannot say that you can't talk about that agreement with other employees, or you can't assist other employees with regard to that. Now, you might be limited in disclosing what you've gotten as a result of releasing and holding confidential, but you cannot be completely gagged from discussing what had transpired, because that constitutes denying people their Section 7 rights to get together with other employees, whether they're current employees or former employees. In that regard, there were other cases that were decided that said if somebody advocates for someone who is an immigrant who had lost their visa status and no longer can continue to work at a particular location, that advocacy is still protected under the National Labor Relations Act, even if the person you're advocating for is technically not an employee anymore. It also says that if you're advocating, and they reversed the decision recently, that if employees are advocating for folks that are interns who are not even getting paid, that advocacy is protected concerted activity. This is major stuff. But what I want to focus on today is the question of what can you talk about in the workplace and whether or not that affords someone the protection of the act, particularly Black Lives Matter, talking about race. Now, the General Counsel has been pretty clear in her view in that regard. In fact, she was so clear that there was an advice memo that recently was released. Now, an advice memo is usually a memo that is issued by a division of the General Counsel's office and advises the General Counsel as to whether or not a particular scenario, fact scenario, is for the purpose or should be pursued in litigation. And oftentimes those advice memos stay quiet because it's an active investigation and it's not privy to the public. But once that investigation gets resolved and the case gets closed, those advice memos get released, and they're usually very good guidance for practitioners and for workers as well. So one advice memo that just was issued in February was called Kaiser Permanente, and it was about a medical school and the discussion that a professor, a practitioner, a physician had with students relative to the question of race. In February of 2023, the NLRB released this memo, and it was about an unfair labor practice charge filed against that medical school by a black woman physician faculty member at the Bernard Tyson Medical School. The school suspended this physician and refused to renew her as faculty at the medical school, allegedly in retaliation against her because of discussion of racial bias in the medical profession during a group meeting with students and another faculty member. At the discussion, the physician talked about how she personally was subject to racial bias and how others in the professions are victimized by that as well. And during the course of the discussion, she wore a "I Can't Breathe" T-shirt because this was in the wake of all of that tragedy relating to Floyd. Now, she also talked about how the dean of the school was clueless with respect to how he was dealing with racial killings that were going on in the vicinity of that community and how it was affecting the population there. Students got upset in this conversation. The conversation was shut down. She was brought to task. She was suspended for a while and then denied her privileges to continue teaching in the school. She went on Twitter about it, and on Twitter she told everything that was transpiring and asked other people to retweet it so that everybody would know about it. So, according to the General Counsel, the medical school violated 8A1 because 8A1 of the National Labor Relations Act, the denial of Section 7 rights, because the physicians' classroom discussions about issues of race faced by black faculty and students, as well as systemic racism in medicine, was inherently concerted and was for mutual aid or protection. They also considered, the General Counsel also considered her tweets to be protected concerted activity because it was a call to arms, a call to support. So, inherent concert was first indicated at that time, and we got an understanding as to where the General Counsel's mindset was in that situation. Subsequently, after the George Floyd tragedies, there were 3 cases that came about involving the wearing and the messaging of BLM in the workplace. Minutes after George Floyd was murdered, minutes away from where George Floyd was murdered by police, an employee at Home Depot store in Minneapolis wrote BLM on their ever recognizable orange apron. In the summer of 2020, an employee at several Fred Meyer's stores in Washington State began wearing BLM pins and face masks, but were disciplined and threatened with termination if they persisted. In early June of 2020, employees at Whole Foods throughout the country began to display messages related to Black Lives Matter on their work attire, including face masks, buttons, and pins. Although Whole Foods made public statements in support of BLM, it banned the display as against the dress code. These 3 cases presented the burning question: can you talk about Black Lives Matter in the workplace and get the protection of the National Labor Relations Act? Now, all those decisions went in different directions. You had two administrative law judges that said, no, this is too attenuated. This is not terms and conditions of employment. This doesn't afford anybody with any kind of protections. This was about something that was going on that was, albeit tragic, and political, and a basis for a lot of social demonstrations, but it did not connect up with the workplace. Whereas another administrative law judge said, well, quite frankly, people don't check their race at the door when they come to work. She said that she recognizes that racism in the workplace racism is a workplace issue, and wearing the insignia constituted mutual aid and protection. Thus, the store's prohibitions and discipline of employees were unlawful. The store, of course, appealed this to the board, and that decision is still pending. But the one ALJ who decided the Whole Foods case said the opposite. Too attenuated. Has nothing to do with the workplace. There's no nexus. And it's kind of interesting because in Whole Foods, it involved an individual who donned the BLM marking on his apron, on their apron, primarily because of not only what was going on outside, but was going on inside. There was a Black Lives Matter display that he helped put up that was defaced. There were particular employees that were being treated hostilely by another employee, but just because of their race. And all this was presented to management. And it was during that meeting with management that management said, hey, you got a Black Lives Matter thing on your apron. You got to take that off. And the employee refused to do so. The employer didn't fire him, but said, if you continue to do this, we can't give you shifts. You can't continue to work. And he says, well, you leave me no choice. And I resigned. And then he filed his charges. So the question not only is this activity, protected concerted activity, but is it also what the general counsel was going for, inherent concerted activity? And what do we mean by that? Well, there is some conversations that you can have in the workplace about seniority, about workplace safety, about wages, and which would be automatically concerted activity because of the nature and the content of that conversation. It automatically assumes that whatever is being discussed counts for the employees as a whole. So you don't have to have a gathering of employees around you, or you don't have to be sent by employees in order to establish that concerted nature. It's inherently concerted, and it has been recognized as such. The general counsel is saying, well, these kind of discussions, Black Lives Matter, should also have that same status, and they attempted to promote that and argue that in front of the administrative law judges. Now, the judge that found the activity to be the Black Lives Matter activity to be concerted activity in her case, which was the Fred Meyers case, she said that I won't deign to go there. I'm going to leave that decision up to the NLRB because that's a new area that they'd have to deal with themselves. But I'd have to say I got my own opinions about that. And certainly these folks who have historically been the victims of the greatest wage theft in the history of the creation of the United States might need to be heard about this issue. This is paraphrasing. So what did the NLRB do? Well, the NLRB did not go towards deciding on the question of inherent concerted activity, but it did find that because of the facts that were involved in that case involving Mr. Morales, that there was nexus to the workplace that justified Black Lives Matter being considered protected concerted activity. I'm going to stop here, but I wanted to say one thing that the board did say relative to the question of inherent protected concerted activity. The board declined to reach the issue of inherent concerted activity, but left open the door, writing that in declining to take up this issue, we do not suggest that protesting workplace racial discrimination is any less central to the exercise of Section 7 rights than seeking to improve wages to obtain desirable work schedules or to protect job security, all of which we have found inherently concerted. And we express no view as to whether, in a future appropriate case, we would find protests of workplace racial discrimination to be inherently concerted. So who knows what will happen next in that regard. I can say more, but my friends got more profound things for me to talk about, and I will be accepting your questions in due time. Thank you.